I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Hey everyone, this is Alice. It's so great to be with all of you on a second week of Legal Briefs. And I'm joined, as always, by my co-host, the loquacious Brett.
Loquacious. Hi, Alice.
Welcome back, everyone. And jokes on all of you because I forgot to record, and we recorded perhaps the best hour in podcast history, and we didn't press record. So we are now pressing record, and we'll see what happens. But the greatest hour of podcast history is now in the ether, never to be recorded. Sorry, Brett.
And that's what would have happened, except I noticed we weren't recording. So you did not lose that hour of brilliance that you would have lost otherwise. So you're welcome, Alice.
Look, I was so excited to get to the hitting news. I just started before we even started recording. That's how excited I am because, you guys, thank you so much for joining us and subscribing and for leaving your 5-star reviews for Legal Briefs when we dropped last week. We've been overwhelmed with your amazing support and words of encouragement. And we are so excited to update you on a couple things that listeners like you have written to us about. So today we're going to cover the Shin versus Ramirez Supreme Court case. And the question is whether the Supreme Court has gutted the lifeline for prisoners who claim wrongful convictions. And also we're going to delve into the Moab murders, which was a story that we covered a couple months ago on our Prosecutors podcast on a different feed.
Yeah, we got a lot of requests to cover this Supreme Court case. I do have to warn you that we're nerding up today, guys.
It's a lot of law. It's a lot of law.
There's a lot of law going to be talked about today. A lot of Supreme Court cases, a lot of precedent. So if you hate that kind of stuff, you definitely came to the wrong episode. But those of you who complained because you thought the Amber Heard Johnny Depp thing was way too pop culture, well, congratulations, because today it's going to be very different. It's going to be very different. But this is a topic that a lot of people have mentioned to us, and it's kind of funny. So as part of my job, I do a lot of appeals, as you guys know. Alice is the sort of master trial lawyer in the group, and I do a lot of appeals and occasionally dabble in on the trial side. But because of that, I read a lot of Supreme Court opinions. So when the Supreme Court's issuing its new opinions, particularly if it's in criminal law, I will check it out to see, is this going to have some effect on what we do? And I remember when this case came out and I read it and just thought, okay, no big deal, and kept going. And frankly, no one in the United States really noticed it either, I think. And then, of all places, The Guardian in Britain runs a story on this case. As Alice said, the headline was Supreme Court Guts Lifeline for Prisoners Who Claim Wrongful Convictions. I don't know why The Guardian was so interested in this story, but they wrote this story and it kind of caught fire over here. And then all of a sudden you had people doing TikToks on this. People were concerned about it. I saw Maggie Freeling was worried about it because, Maggie does a lot of wrongful conviction stuff. And there was this feeling after this Guardian article that because of this Supreme Court case, that was it. If you have a wrongful conviction, you're just in trouble. And so we thought, let's take a look at this. Let's see what it actually does and answer some of the questions that you guys have asked of us. So let me give you a little bit of the factual background. So the case is called Shin versus Ramirez. There were actually two cases that were combined into one, though I think Shin versus Ramirez is what it's going to end up being called. In addition to Ramirez, there was also a defendant named Barry Lee Jones. And what these two people have in common is they both are on death row in Arizona for, in some ways, similar murders. So Ramirez raped and murdered his girlfriend's 15-year-old daughter, stabbing her 15 times in the neck with a box cutter. He then stabbed his girlfriend to death. And I just got to say, those of you who don't follow the death penalty cases, the facts of the cases are awful. You know, even by true crime standards, they tend to be really, really terrible facts. The other person, Jones, was accused of raping his stepdaughter and kicking her in the stomach so hard that it ruptured her intestines, and she actually died of sepsis later on. So both these people killed children. In Ramirez's case, he killed two people, and both of them were sentenced to death. So typically what happens when you are convicted of something like this, you may challenge your conviction, but usually you're going to lose. Unless you can point to some crazy legal thing or some really weird fact thing, you're usually going to lose. So what you do is you say, I had an ineffective lawyer. And both of the people in this case say that. Ramirez says that his trial counsel didn't put on enough mitigation evidence that might have convinced the jury not to give him the death penalty. You see this a lot in death penalty cases. Most death penalty cases are not about whether or not the person is innocent. They're about whether or not the person should have gotten the death penalty. And because you can bring anything into mitigation, what you often hear are these stories about abuse as a children, mental illness, intellectual defects, all these things where you're saying, yes, my client is a terrible person who killed someone, he should go to jail forever, but he shouldn't get the death penalty. So Ramirez is not saying he didn't stab these people to death. What he's saying is, yeah, I stabbed him to death, but I had all these mitigating factors. I shouldn't have got the death penalty. Jones is actually saying he's innocent. He says his counsel didn't do enough investigation, didn't put on enough evidence, and that if he had, he might have been able to show that given the young girl's time of death, he couldn't have been the one who caused the injury that led to her death. And he got an expert to talk about this. And basically his argument was, if I had put this evidence on at trial, maybe I wouldn't have been convicted, so I should get another shot. But the problem both these people had, and we're going to get into why this matters, neither one of them raised this issue in state court. They waited till the state court had denied their petition, a habeas petition. Habeas corpus is this thing in the Constitution that allows you to challenge your confinement or your punishment. It's different from a direct appeal. And basically what you say is, my constitutional rights were violated, so I shouldn't be in jail. In this case, the constitutional right that was violated is I am entitled to effective counsel. If I have ineffective counsel, my constitutional rights were violated, and I'm being held in contravention of the Constitution. So that's what you're saying in your habeas petition. The first place you file that, though, is state court. State courts get the first shot at it. Neither one of them made these arguments in state court. They waited until they were in federal court. And they not only wanted to raise these issues in federal court, they wanted to have an evidentiary hearing in federal court where they could call witnesses and develop the record and have people testify. The problem is that they were facing is the statute governing habeas appeals, generally speaking, bars these kinds of evidentiary hearings.
Right, Brett. And so, as lawyers, when you hear this, the outcome is not surprising whatsoever. In short, this is about habeas relief under a statute called shorthand EDPA, and that stands for the Anti-Terrorism and Effective Death Penalty Act. Its intention was to create a system that ended the limitless appeals of the past. We've talked about this where when there's no finality to a case, when there's just appeal upon appeal, it's bad for the judicial system because it sucks up a lot of resource. It's bad for the victims and their families because there's no finality to the justice that they are seeking. And it's really not good for anyone in society because, again, it takes so much money and resources. And when there's no finality, there's essentially no justice. And so that's what EDPA was trying to address. And people on death row for 30 or 40 years, they would typically be filing the same appeal over and over again because our death row system is not swift. Just because you're put on death row, you're typically there for decades at a time. And it had a state component and a federal one, just like Brett mentioned. So if you commit a state offense, the state has primary jurisdiction over your case. And that makes sense because that is the sovereign. That is the sovereign that has convicted you, and that is the one who has jurisdiction over the appeals that you have. Now, the only federal court that can rule on a direct appeal from a state conviction is the Supreme Court, the United States Supreme Court itself. Habeas allows for a second appeal that can go through the lower federal courts. However, it has to go through the state courts first. That's because, think about fairness. It's the state court's jurisdiction. So before the federal courts step into another sovereign's courts, the state court gets to first develop the evidentiary record. And essentially, if they find a problem, the state courts can fix their own problem first. And after that evidentiary record is developed in the state courts, then the federal courts use that record, developed in the state, to rule on the case. This is a bit of an oversimplification, but the point is, and the rule has always been, that you don't develop the evidentiary record in the federal court, but in the state court. What does this mean practically? All that you heard Jones and Ramirez wanted to develop. They wanted to call witnesses and experts and put people on the stand to develop their factual argument about whether they were innocent or whether they had mitigating factors that meant they should not be sentenced to death. Those testimonies are all supposed to happen at the state level, in state court. By the time the federal court gets the habeas appeal, all they have is a very thick stack of the record. Papers. They go on the papers. They don't call witnesses themselves.
And let me just say, those of you who are listening to this are getting an entire Fed Courts class in about 30 minutes, which is kind of insane because Fed Courts is the hardest class in law school. So, congratulations if you're a law student who's listening to this, because habeas is really complicated stuff. And I think you can already see this, just all this interplay between the states and the federal courts and how the federal courts work and the fact that the federal courts defer to state courts. And we've talked about this in the other podcast. The United States is a very unique place where these states are real, powerful sovereigns. They are not just lines on a map. And particularly in crime, the federal criminal system has grown a lot in the last 50 years or so, but still the state courts are the primary enforcers of the law. Most of the things you see on television, the television shows, whatever, they're all happening in state court. Most of the crimes you think of, all state court crimes. So the state courts have primary jurisdiction, and like Alice said, they can fix the problem the first time around. You go into state court, you raise the issue, the state court can say, yeah, you know what, you're right, let's do this again. And then the federal courts are never even involved. The federal courts only become involved if you go all the way through the state court system and the state court says, no, we don't see a problem here. And then they hand off that record to the federal courts. And in some ways, federal practice is a lot easier than state practice because you have this nice compiled record, and that's what it's about. And there's no extraneous stuff. There's no calling witnesses. You're writing briefs and arguing to judges based on that record. I have done this work. It's called 2254, and it is kind of crazy. I mean, you just have like a big stack of documents, and you read through this record, and then you build your case based on what you have. And usually there is no evidentiary hearing in federal court. Now, here's the complication here. The question for the Supreme Court in this case is, after this case goes to the state court, counsel raises a new argument with new evidentiary questions in federal court. What is the federal court supposed to do? Do they have an evidentiary hearing if there was no evidence developed in state court? Or does federal law foreclose that and not allow them to have this evidentiary hearing? The concern, which I'm sure you can imagine, is that by bringing these claims so late in the game, you're dodging the state court review and are stalling for time by raising new claims that now have to be fully litigated with new evidentiary hearings, new witnesses, and all those complications. You might wonder, why wouldn't you just do it in state court? Well, because the state court has primary jurisdiction, even if this habeas appeal makes it to federal court, it's not a blank slate. The federal court looks at the state court decision, and unless the state court decision is contrary to reason, they let it stand. So even if the federal court disagrees with what the state court found, there's heavy deference given to what the state court has decided. It makes the bar very high in federal court. But If the state courts have not passed on the question, there is no deference. So if you can bring this for the first time in federal court, then you don't have to worry about the deference. The federal court may be more friendly to you than the state court. Another thing to consider. These are all the practical things that you don't hear about when you read about this in the news. Most habeas cases in the state start in the court that tried the case, with the judge that tried the case. The judge has a deep understanding of the case, and he appreciates better than most arguments like the mitigation arguments. You know, on a cold record, when I was talking about how you just have a stack of papers and you read the papers, you may have differing opinions on that on a cold record. But when you've been there and you've seen it and you heard the arguments of the counsel and you saw the witnesses and you evaluated their credibility, and then you're having the habeas appeal, it's much easier for you as the judge to say, you know, I hear what you're saying, but that wouldn't have changed anything. I was here for it. Wouldn't change a thing. That's another reason there's deference to state courts, because the state courts typically have a better understanding of the case. So if you really want a new bite at the apple, you want to get it out of state court to a new judge who doesn't have that familiarity and is just looking at this cold record and maybe doesn't have that preconceived notion of how the trial went and how the trial should have gone. The problem that Ramirez has in this case is the statute itself, EDPA, that we just talked about, basically forecloses having this hearing. It says, if a prisoner, quote, has failed to develop the factual basis of a claim in state court proceedings, a federal court may hold an evidentiary hearing on the claim in only two limited scenarios. Either the claim must rely on a new and previously unavailable rule of constitutional law made retroactive. So in other words, the United States Supreme Court decides we're going to change the law, or we're going to recognize a new right, or we're going to say that something that was a crime isn't a crime anymore, and we're going to make that retroactive. So everybody who ever faced this problem before can now raise it anew. In that case, you can have one of these evidentiary hearings in federal court. That's the first instance. The second one is a factual predicate that could not have been previously discovered through the exercise of due diligence. So, this is something that you didn't know about in the first instance and couldn't have known about. So it's new evidence. Newly discovered evidence is the way it's described. You see that a lot in these cases, in innocence cases, where they discover a witness they didn't know about, or they find out that the police had covered up evidence, or they discovered new DNA evidence, something like that. If you have that, and if that evidence would demonstrate that the person is innocent of the crime to the extent that no reasonable fact finder would have convicted them if they had that evidence, then you can have this new evidentiary hearing. So if you have sort of an actual innocence claim with newly discovered evidence, then you can have an evidentiary hearing in federal court.
I want to jump in there real quick because I think a lot of people have heard that language, that it's previously unknown or information that was not discovered previously. Note that the statute's very clear that it's not just any fact that you didn't know previously. It has to have been a factual predicate that could not have been previously discovered. So imagine a cover-up by the police that could not have been discovered. It can't just be anything new information that you know, because there is a limitless universe of information that you may not know that could have nothing to do with your case, or that could have been discovered and was in the discovery to you, but you somehow missed it.
Exactly. It's a pretty high standard and it's a pretty high bar, and you can see how Ramirez and Jones, they don't meet that bar. The things that they're saying that their counsel should have done are things they would have known about or should have known about at the time. And yet, not only did their counsel not raise it in trial, but their habeas counsel didn't raise it in the state court during habeas. So in a way, they almost have double ineffective assistance of counsel. They were ineffective in trial, and then their new counsel was ineffective in habeas because they didn't raise these issues. Now, here's where this gets a little strange and where a lot of the confusion about this case came along. This seems pretty clear-cut. You didn't raise it, it's precluded. And I'll just tell you that waiver and procedural default of issues you could raise are they're just standard. It's just what you do. I see these cases all the time. I handle a lot of cases, a lot of habeas cases, and you will see all the time people attempting to raise issues that they should have raised on a direct appeal and they didn't raise them. Those are waived. They can't raise them now. It's not even controversial. They just can't raise them. They're waived. It becomes a little bit more important here because these are death penalty cases. And so they want to raise these new issues and in an attempt to get off of death row. Well, the Supreme Court, although ordinarily these issues are just waived, they've kind of muddied the waters just a little bit. They've said in the past, in a case called Martinez, that you can raise a new legal claim, in a situation where equity demands it, so where fairness demands it, where it really should have been raised before but wasn't because your habeas counsel was ineffective. So they will allow you to raise the issue. So in this case, these two men can raise an ineffective assistance of counsel claim. But here's the question. Are they allowed to have an evidentiary hearing to further develop that claim beyond whatever the record is now? That was the question. And the court said no.
That's right, Brett. And that was a very narrow question. It's not whether you can raise it, but whether you can then have an evidentiary hearing. You can raise the issue, but you can't have an entirely new evidentiary hearing to support it. If the evidence isn't already there, you are out of luck, at least in that appeal, even if it was your counsel's fault that it wasn't developed, and even if that counsel was ineffective. So this actually is entirely consistent with the statute, but the reason it's confusing to people is because of the fact that the Supreme Court has said, kind of contrary to the statute, that you can in fact raise this new claim. They're just saying you can raise it, but like before, you can't develop your record if it doesn't already exist. So it's really a big stretch to say that this holding gutted anything, as it was fairly rare anyway. It really only affects claims in which the defendant's habeas counsel fails to raise an ineffective assistance argument in the state court. But habeas is almost entirely about ineffective assistance of counsel. You can't even raise that claim on direct appeal. So this kind of claim should be fairly rare anyway. Furthermore, it's only recently that the court allowed you to raise the legal issue itself, like we just said. That was decided in a case called Martinez, which was decided in 2012. So until 2012, the statute was read by the text, which is that these claims could not be raised. Now, from this point forward, from Martinez, it's incumbent on counsel to fully litigate the evidentiary issues in state court. Obviously, if you discover new evidence, that's a reason to get a second bite at the apple, as the statute provides for. But if it's there when you file the habeas appeal, you better raise it.
And, a couple things about this, because there's been a lot of people who, even in the legal community, who are confused about Martinez and this case, Ramirez. And why can you raise the claim, but you can't have an evidentiary hearing? The reason for that is procedural default of an issue is a court-made rule. So the courts have rules that if you don't raise a legal issue that you should have raised before, it's procedurally defaulted and waived. You can't now raise it further down the line. The court in Martinez said, because this is a court-made rule, we can adjust it. So we're going to give an exception to the court-made rule of procedural default on an issue and allow you to raise this issue later on. And in that case, which was a 7-2 decision, the majority was very careful to say, this is an incredibly narrow ruling. We're giving you very narrow relief, and we're not going to let it go any further than this. And in the dissent, it was Justice Thomas and Justice Scalia in dissent, and they basically said, yeah, right, it's going to expand. People are going to seek evidentiary hearings. They sort of saw this coming. But the majority said, no, not going to happen, very narrow. The reason this is different is we've read you the statute. It is a statutory rule, a law passed by Congress, that you cannot have an evidentiary hearing in federal court except in narrow instances. So you can't do it under the Martinez rule. Martinez allows you to raise the issue. The statute prevents you from having an evidentiary hearing. And the court said, look, we can adjust a court-made rule, but we can't just ignore a statute passed by Congress and signed by the president. That's kind of not how it works in our system. So, the simplest way to fix this, if you think this is a problem, is just to have Congress change the statute. If Congress wants to have evidentiary hearings attached to these Martinez rulings, if we think this is a big problem, Congress can change the rule to allow evidentiary hearings when Martinez applies. So in a circumstance where you can raise a legal issue under Martinez, that'll be the third exception to when you can have an evidentiary hearing. You can raise one then. The other thing about this, the gutting. So the dissent in Ramirez, where this language comes from, the dissent in Ramirez says that this guts Martinez. That's what they're talking about. It's gutting Martinez. So they basically say, look, this renders Martinez irrelevant because how can you ever prove this if you don't have an evidentiary hearing? Now, the easy way to do that is just the record makes clear that there's all this stuff your lawyer should have done, and you can use that record to support your argument. That can happen a lot. So really, even more narrow, this is a case where you have the claim, but there's nothing in the record to support it. Then you're in trouble under this. Here's what's interesting about this. Martinez, as I said, was a 7-2 decision. There were 2 justices in dissent. 2 of the justices that were in the majority were Justice Alito and Justice Roberts. If Justice Alito and Justice Roberts had joined the 3 dissenting justices in this case, they would have had the majority. So what you have is a situation where the dissent is saying to people who were in the majority in Martinez, you are gutting Martinez. And that doesn't really make sense. If you were one of the people who helped establish Martinez, you would have an interest in not seeing it, quote unquote, gutted. So you can see how, while that's good rhetorical language, it doesn't really make sense given the lineup that you have in this case.
And that's what The Guardian doesn't get. They don't see how the justices vote and know the historic writings of each of the justices here. And so it's a great headline, and I'm really surprised. I wonder who gave them a tip-off about that headline. But the headline, as you can see, is utterly misleading. And this was pretty deep dive into the law, but I think it's helpful and shows you why a headline is an easier grab, an easier clickbait than, at this point, we've been discussing this for almost half an hour to fully explain why that one sentence by The Guardian is utterly false.
Yeah, and look, this is something we're going to do a lot of, is sort of misleading headlines in the law, because the law is really complicated, and it is really difficult to reduce things like this down even into 30 minutes. I mean, we are giving you guys, this may have seemed really deep and nerdy. It's really the barest discussion of this. We could talk about this case for hours. We could go into sort of the historical intricacies of habeas if we wanted to.
To show you just how surface this is, the Shin versus Ramirez opinion, which you should all go read, is 47 pages. And we have barely touched upon, some of that is background, and the margins for Supreme Court opinions are very strange. But it is a long opinion, and there are dissenting opinions as well as the majority opinion. So there's dialogues among the justices as well. So what you are hearing from us is the surface. But what we hope to provide you is an ability to look at a headline and intelligently recognize that that is not representing what's actually happening within our law. And also not to go up into alarms, because that's what headlines are for, to just get the hairs on your neck up without actual substance. All right, let's move on to the Moab update. As you guys know, we covered the Moab murders a couple months ago. Well, since we published our update of the murders of Kylen Turner and Chrystal Schulte, we've learned much more about what the police believe happened. The police have identified Adam Pakinczewicz, a 45-year-old man who worked at the same McDonald's as Chrystal, as their primary suspect. Days before the murders, Adam had complained to the manager at the McDonald's that Chrystal received special treatment because she was a lesbian and the manager was also in a same-sex relationship. The day they were murdered, Kylen and Chrystal drove their motorcycle back to McDonald's and then took a car back to their campsite. We know it is the same day because they left it in the parking lot as opposed to parking it in a garage. It is believed they intended to use the car to move the campsite due to the, quote, creeper they had described to friends the night before. It is likely that Adam followed them from the McDonald's back to their campsite and murdered them. After the murders, Adam left Utah, not even stopping to pick up his paycheck. A few weeks later, he ended up killing himself. But before he did so, he confessed certain details of the crime to a friend. Those details were known only to investigators. So it appears that the creeper that Kylen and Chrystal told their friends about the night before they were murdered, and then the text as well that night after they left their friends, was really just a red herring. I don't think the creeper was Adam because Kylen and Chrystal knew who Adam was, and they did not mention Adam by name. And this really goes to show you how in a lot of these cases, when we have imperfect information, it's so easy to latch onto something that seems out of place when you think, absolutely, this has to do with something to do with the answer to what has happened here. But as this case has shown us, there are red herrings everywhere. When we have imperfect information, we can't quite know what's important and what's not. And of course, we try to cover all of it in hopes that someone knows something and latches on to one of the facts that we've said. But this is a huge, huge, huge lesson for all of us that facts may seem strange. Facts may seem like they absolutely have to do with the answer to whatever true crime story we're talking about. But red herrings, in fact, exist.
No, you're right. This is a great reminder to everyone because we all have a tendency to latch onto something and build our entire theory around it. And we saw this in John Benet Ramsey. There were people who just could not accept that the pineapple might be a red herring. It has to be involved. Sometimes there are coincidences. Coincidences happen. This is a huge one. It really seems like the creeper played a role in this because if it hadn't been for him, they might not have gone back because they wouldn't have needed to move their campsite. They were moving their campsite to avoid this creeper. And in doing that, they opened themselves up to being followed by Adam, is what seems like happened here. But the creeper himself, red herring, didn't have anything to do with it. We talked about the possibility the creeper was a red herring, but we basically said, seems so unlikely. How is it possible that two people could be talking about someone creeping them out the night before they were murdered and that person not be involved? And yet, in this case, it seems like he wasn't. And I think this is the resolution of this case. The facts that we have, I don't know why it took so long for the police to announce these facts. Yeah, I think Adam's body was only found recently. It was sort of what I was led to believe by some of the stories I read about this. So I think they were waiting to find him. And then once they found him and they realized he was dead, they said, okay, this case is solved. I mean, they haven't said it was solved, but to me, you add all this up. The holdback evidence here was important. We talk about holdback evidence all the time. Apparently, this man knew information about this murder that nobody else knew, and he shared that information. So I feel like the police, I expect soon the police will close this case and will make it very clear that Adam is the murderer. You know, you don't always get justice in this life. Sometimes you got to wait till the next one. But I think at least we know who killed Kylen and Chrystal, and their family can have some peace knowing that the person who did it faced a certain kind of justice.
I think that's right, Brett. I think this case has been solved, and I'm really happy for the family members that they have some closure. But it doesn't take away from the tragicness of this case. It doesn't take away from the tragicness that Adam killed himself, and he doesn't get to face justice in the court of law for Chrystal and Kylen's family to see.
So before we close up our CLE for today, we've been talking a lot about habeas and lawyers. You have a right to an attorney during your trial and during your appeal. But, and you may not know this, in a habeas appeal, you do not have a right to a lawyer. You have no constitutional right to representation in a habeas action, which is one reason why, if you do have a lawyer in a habeas action and that lawyer is ineffective, that is not actually a cause of action because you don't have a right to a lawyer. You don't have a right to an effective lawyer. So if your lawyer, for whom you did not have a right to, screws something up, that is not something you can rely on to have sort of a second bite at the apple if you appeal your habeas decision.
Indeed. So, there's your education for the day. Thank you guys for joining in with us. And until next time, I'm Alice.
And I'm Brett.
and this is the Prosecutor's Legal Briefs. Hi everyone, this is Alice, and I'm joined as always by my loquacious co-host. Dang it.
Loquacious.
I know. Hi everyone, this is Alice, and I'm so glad to be here a second week with y'all. Man, that came out weird. We're just gonna start over. Hey everyone, this is Alice. It's so great to be with all of you on a second week of Legal Briefs.